Mr. Jones.
My Lord. I had just before the short adjournment taken the court to some of the findings in the FTT's decision. There were just two more in that context that I wanted to highlight. Paragraph 201, which is internal page 56 of the decision, it's core bundle page 576. It's part of the sections that we were looking at just before short adjournment. And it's the... I took your lordships to the cross-reference to the reasons relating to the detailed metocean studies. That's in the first half of that paragraph. But then in the final 5 lines, the FTT finds that without that data, i.e. the geotechnical and geophysical studies data, the wind turbines could not be specifically designed, and this, in my opinion, would have rendered them useless and unable to fulfill their function of generating electricity. And once they had been so designed, each wind turbine had to be installed at a specific position in each wind farm. And so these studies directly related to the necessary design of the wind farms as a whole. There's a reference there to the concept of necessary design. I'll need to come back to that. The short point is that both the Appellants and HMRC argued that that was actually an error on the part of the FTT to introduce the concept of necessity. That was something that the Upper Tribunal agreed with. That was an error. So the necessary design element needs to be treated with some caution. I'll go on to that when I look at the FTT's decision in a bit more detail. And then the final bit of the findings that I wanted to show the court in this context is on the next page. It's part of paragraph 204. And this is in response to a submission that my own friend had made to the FTT. And it's this factual conclusion. The design of each wind turbine evolved, second line, as additional data was fed into the computer modelling, and the impact of the data relating to the seabed had, as the evidence shows, an impact on the structure of the wind turbine as a whole, and not just to the foundations and the transition piece. So that just highlights the point that, as you might expect in a project of this kind, the design stage is somewhat iterative. So that is the factual illustration that I wanted to show to the court in relation to the point of principle about design. I was going to move on to installation next. Just before I do that, as a result of some research that those behind me have done, I just wanted to mention to the court in relation to the question that my Lord Justice Zacaroli had put to me about the impact, if any, of Limb B in relation to Section 11, subsection 4, and when that came about. We've unearthed that that particular aspect of the code was introduced by Section 16 of the Finance Act 1957. If it would be useful, we're happy to supply the court with a copy of the section. It introduces that requirement into the legislation and relevantly states that the section is deemed always to have had effect. So effectively it was introduced with retrospective effect. There is a carve-out effectively to preserve the claims that had been successfully made in relation to Guthrie, in effect. But the key point then is that in relation to Barclay Curl and Benedetto and the cases subsequent to that, that aspect of the legislation was in force effectively and wasn't considered to have any bearing on the meaning of the term on the provision of.
Sorry, could you just repeat the reference? Finance Act?
Yes, it's the Finance Act 1957.
57, 67?
57.
Yeah.
Section 16.
Thank you.
I think we can easily find that online ourselves, so don't worry.
Thank you. So I was then going to turn to installation. And dealing first, if I may, just at the level of principle. There are 3 points to make in relation to that. The first point is not controversial. It is that expenditure on the installation and transportation of the plant in question is within the scope of what qualifies. And we've already seen the authority for that proposition in Barclay Curl and Benedetto, and it was also stated more recently by my Lord Justice Newey in Inmarsat, paragraph 66. The second point is that it seems to be accepted on all fronts, by which I mean by the Appellants and HMRC and the Upper Tribunal, that it is useful to approach the concept of installation in this context along the lines referred to by the Court of Appeal in the Urenco case. And that case is in the authorities bundle at tab 27. It's volume 2, and it's PDF page 510. The case concerned capital allowances claims in the context of the construction of a facility for handling radioactive waste. There were various issues. The one on which I focus concerns an argument by Urenco that various structures that it had erected qualified for allowances on the grounds that they were constructed for the purpose only of installing plant or machinery. And consideration of that particular issue begins at paragraph 154, which is page 554. So this is dealing with Urenco's cross-appeal ground 2, which is concerned with item 22 of list C, which is a list of particular items set out within the Capital Allowances Act. And as is stated at 154, item 22 of list C saves from the disqualifications in sections 21 and 22 of the 2001 Act expenditure on the alteration of land for the purpose only of installing plant or machinery. So the essential question in the context of this particular issue is whether the work in question fell within the scope of that term. And that required some focus on the concept of installing plant or machinery in that particular context. And at paragraph 162, Appeal sets out that the decision of the FTT, this is page 556, the decision of the FTT on the purpose or purposes for which the relevant alterations of land were made was in principle a decision on a question of fact, which would normally be immune from challenge on an appeal confined to questions of law. Undeterred, however, Urenco argued in the Upper Tribunal that the FTT's decision involved an error of law in that the separate safety purposes identified by the FTT were all installation purposes, and they could not logically be dissociated from the actual process of installation. The Upper Tribunal was unimpressed by this argument, saying at 145, the FTT regarded the purposes described in the final two sentences of 151 as not being for the purpose only of installing plant and machinery. We consider that they were justified in doing so. Mr. Peacock's proposed construction of installing would give an extremely wide meaning to the term and afford little weight to the word only. No case was put forward why a purpose of construction would or should lead to such a result, we agree with the Upper Tribunal in SSE that installation is apt to describe a process of integrating one thing into another, and not the construction or manufacture of an asset before it is installed. We also agree that the use of the word only makes clear that the saving in item 22 was intended to be a limited one. And then, following that quote, I respectfully agree with the Upper Tribunal that the saving in item 22 must have been intended by Parliament to be a limited one. That is clear not only from the use of the word only, but also from the focus on the installation of plant or machinery and the requirement that the relevant alteration of land must have no other purpose. The problem of Urenco's much broader conception of what installation means in this context is that in a case of the present type, the saving in item 22 would in practice swallow up the basic disqualification of the provision of buildings in section 21. Where buildings are excluded from the general prohibition, specific language is used in list C, which narrows down the scope of the exception. Thus, the immediately preceding items in the list cover expenditure on item 20, buildings provided for testing aircraft engines run within the buildings, and 21, movable buildings intended to be moved in the course of the qualifying activity. And then at 164, fourth line, the wording of item 22 is not apt to include cases where the purposes to be served go beyond the installation of extraneous pieces of equipment, and still less to include cases where the alterations consist in works of construction of a structure or building, which, when completed, is intended to function as a single item of plant on its own, in its own right. In common with the Upper Tribunal, I find assistance in the point from the reasoning of the Upper Tribunal in the SSE case. The relevant passages are set out in the UT decision at 142, from which I quote the following extracts. 127. The OED defines install as place, an apparatus, system, etc., in position for service or use. We accept that the case law does not limit the term to simply taking a prefabricated asset and placing it in position. However, in the case law which we have reviewed, the common theme is the process which involves the integration, often with a degree of complexity, of an article or articles which have already been made into another article, structure, building, or even the land itself. In none of the cases that we've referred to has the term been held to include the creation of an item of plant in situ. It seems to us that item 22 in list C is confined to items which need to be installed separately from the process of manufacture or construction. As the UT in the present case went on to observe at 143, when SSE reached this court, Lady Justice Rose said at 69 that she saw the force of the Upper Tribunal's reasoning on the question and did not dissent from it, although she declined to come to a concluded view in the abstract, given the elastic nature of the words used in these provisions. Given the high level of generality at which this part of the case was argued before us, I too would be reluctant to express a concluded view on the precise scope of the concept of installation in item 22. Nevertheless, I feel little doubt that a restricted meaning along the lines indicated by the Upper Tribunal in SSE is appropriate, and that it cannot have been the wide meaning for which Urenco contends. On that basis, I consider the FTT was fully justified in identifying non-installation purposes, which meant that the sole purpose test in item 22 was not satisfied, and I would also respectfully endorse para 145 of the UT's decision quoted above. Now, obviously, it's important to keep in mind that that was a consideration of the interpretation of the term installing in the statute. Whereas the concept of installation that has to be considered in the context of these appeals is in effect the judge-made concept of installation, which has been recognised in the case law as being within the scope of the term on the provision of plant within the Act. But it is logical that there be some commonality between the two concepts for this reason. The concept of installation that was being considered there in item 22 of list C exists within the context of a list in the Capital Allowances Act 2001. And moreover, as is recognised in Urenco at paragraph 100, which is page 540, the items in that list are a statutory recognition of previous cases, in large part. So at 100, it's stated it's common ground that the legislative purpose of the amendments to the Capital Allowances legislation enacted by the Finance Act 1994 and restated in Chapter 3 of Part 2 of the Allowances Act 2001, which is the chapter in which one finds, amongst other things, List C, was to promote certainty for both taxpayers and the revenue, and to prevent further erosion of the boundary between buildings and structures on the one hand and plant on the other hand, which had been brought about by a series of court decisions, while at the same time entrenching the effect of those decisions and of established revenue practice. See the comments of Lady Justice Rose in SSE. So the word installing, the concept of installation within the confines of that part of the Act, actually derives ultimately from case law that was then entrenched, as explained in List C. So although at first sight one thinks, well, this is dealing with the concept of installation in a statutory provision, we don't have that here. We are trying to work out the boundaries of installation from the judge-made law. Actually, they are far closer relations than might first appear.
Is it really a relevant relationship? I mean, the statutory words we're concerned with don't include installation at all. Supposing that they did, there'd be a question as to whether the later legislation could be taken to cast any light on the meaning of the earlier legislation. Here we haven't even got a word in the earlier legislation. So why should what Parliament thought in enacting this later legislation help us?
Well, suppose that if it had had the word installation in it, Parliament has enacted the same concept within the same part of the Act, then it would at least be a fair working assumption that they're to have the same meaning. But the enactment of the concept of installing within that term, as I've endeavoured to explain, comes itself from case law that is concerned with this very area.
Meaning that we infer that Parliament understood the case law to mean a particular thing, and if so, that we should take it that Parliament was right or wrong about what it thought the thing meant?
I don't know that one needs to go that far with it. There is a consideration of what the concept of installation means within the same part of the Act that we are dealing with here in this case. I suppose the question might be put as to why would a different meaning or conception of installation be arrived at in our context from the one that was arrived at in the context that's being considered in Urenco. There is no obvious reason why one would differ from understanding installation in that way. Now, as I've said, the concept of installation that we are grappling with is a judge-made concept. And to some extent, the Upper Tribunal says, well, that being the case, and that just being an extrapolation of what's meant by on the provision of, we shouldn't get into the granularity of what installation means, because ultimately we always have to look at the words of the statute, which is this expenditure on the provision of. To some extent, that's a fair point, but we have a judge-made concept of installation which qualifies. It is fair to try and understand what the scope of that is. It's no good just retreating back to the statutory words and saying, well, we can abandon that exercise because ultimately we take them back to the words of the statute. So in trying to understand what the scope of that concept is, it is, in my submission, a fair starting point at least, to see how that word has been construed in the very same Act that we are concerned with, in the same part of the same Act, indeed enacting previous case law that is concerned with this area. Now, if one then takes that as being a useful concept of installation or a useful approach, which, as I understand my learned friend's case, HMRC are content to do, then it becomes a case of trying to apply it, or at least trying to understand its boundaries. And that takes me to point number 3, which is really the point of dispute.
So which bit of Urenco do you say encapsulates what we should take installation to mean?
So it's the endorsement of what's said in the Upper Tribunal in SSE, which is quoted by the Court of Appeal at, I think it's 163. Sorry, 165, that installation can be described as the process which involves the integration, often with a degree of complexity, of an article or articles which have already been made into another article, structure, building, or even the land itself.
Yep.
Now, in my submission, the Upper Tribunal appeared content to adopt that as a working definition of the concept of installation. But the Upper Tribunal and HMRC consider that that concept encompasses only the physical act of integrating one article into another.
Can I just ask, how does that fit with Barclay Curl? Because Barclay Curl was the process of building something within a space, wasn't it?
Yes, it was, but that was not, that itself was not installation, it was construction.
Right.
Now the
Sorry, can you just think about that one moment? I'd have to go back to Barclay Curl to see exactly how it came out. So the digging of the hole is the provision of the plant.
well, is part of the cost. The expenditure on excavating the hole is part of the cost of the provision of the plant.
So it has to be part of the provision of the plant.
Yes.
But you say that's not installation.
It's preliminary. The way it's described by their lordships is that effectively it's preliminary to the construction of the dry dock.
Yeah.
I was thinking of, just gone back to Barclay Curl, page 84 of the bundle. They'll read letter D. Well, it does rely on the concept of installation there.
Well, he does, but he's, as I read that part of his speech, he's saying the concept can include more than the cost of the plant, because it can't be said to have been provided for the purposes of the trade until it's installed. Until then, it's of no use for the purposes of the trade. This plant could not even be made until the necessary excavating had been done.
I mean, in one sense, you are fitting the dry dock into the hole.
Well,
Why isn't that installing the dry dock in the hole?
You're building a dry. Well, I mean, I don't know that it necessarily matters in terms of understanding why the expenditure qualified, but installation implies that someone came along with a dry dock and implanted it into the hole. That isn't what they did. They had to create a hole in the ground into which they could then build what would become the dry dock.
Presumably there were detailed architects' plans, drawings, etc., which...
One would imagine...
I mean, on something of that scale, it couldn't have just been done by getting a concrete mixer along, starting at the bottom and working up to the sides.
One would imagine, and there is a description of costs in the Special Commissioner's decision, but it doesn't reveal. The claims are, they're quite generalised in the sense of there's a head of expenditure which is cost of excavation,
Yes.
etc. So it doesn't reveal at granular level exactly what was made up of that.
In ordinary parlance, what obviously was installed, in the natural meaning of the words, were the things like the pumps and so on. Once you've got a concrete casing in place. Then you had all the particular bits of machinery which operated the gates, the locks, and all that kind of stuff.
Yes, I think that is right. But in terms of the actual description of the process of installation, both sides are content to take, at least as a starting point, that description of installation as that process described by SSE.
So, sorry, just before we leave this. So the specific point, SSE, was that it's confined to items which need to be installed separately from the process of manufacture or construction.
Well, the argument that was being run was that you could have buildings that otherwise wouldn't qualify on the ground that they had to erect these structures for the purposes of serving safety functions of other aspects of the plant. And the argument that was being run was that erecting these structures was the alteration of land for the purpose defined in item 22. And that argument was said to go too far, because it would not just involve installing, it's not just installing a ready-made article into another article or into the land. You are building a building, effectively, a structure, which has an existence in and of itself. That was why that was said to go too far. And the concept of installation in that context did not encompass, effectively, erecting a self-standing structure.
Yeah, and that bit doesn't have any significance for us.
Well, it doesn't have any bearing on the definition, the working definition of installation here.
Yeah.
But there's a big danger here of treating what's glosses on glosses as their statutory wording.
And that is something that we recognise.
Yes.
That installation itself is a gloss on the words on the provision
so
of.
Frankly, how useful is this going to be? I would rather feel not very.
Well, if one accepts, and it's accepted at high level, that installation costs count,
Yes.
then it is a fair exercise to try and understand what the scope of that is, in my respectful submission. So I perfectly accept that we are dealing with glosses on glosses to some extent, but it is right and fair that one tries to understand what is within the scope of that judicially recognised category.
Yes, I mean, to me, the question really is how far, if at all, can it sensibly go beyond the absolutely common sense examples anyone can think of a physical piece of plant which you can perhaps order and have to, it might be very large, but you can have to delivered on the back of a great big tanker or something and then lifted in by a gigantic crane in a way you can actually see one thing being locked into place in another.
Yes, that would be covered. But of course, one of the points with plant is that it comes in all shapes and sizes. It can be a horse, it can be a dry dock, it can be a satellite, it can be a wind farm.
Yeah.
Now, what it takes to install that, what it takes to provide that, varies according to the kind of plant. Now, if Parliament accepts that plant can take all those different shapes and sizes, then why is the legislation not also capable of including what it takes to install those different things? Some of which is very complex, some of which are very easy. The Upper Tribunal's distinction, in a sense, one gets the idea that the Upper Tribunal was very clear to set out bright line distinctions. And in this context, there's a bright line distinction between the physical act of installing and intellectual aspects of that process. That is where the Upper Tribunal says the line should be drawn. In my respectful submission, that's an unnatural, unrealistic place to draw the line, because the concept of installation, even just as an everyday word, naturally encompasses both physical and intellectual aspects. As I've said, some items of plant require little intellectual or physical effort to install. Other items of plant, like a satellite, require a great deal of both. And both physical and intellectual aspects are part of the provision of the item in question. In fact, in most instances, particularly where even a modest degree of complexity is involved, it is likely that the process will be iterative in that there's a physical aspect and an intellectual aspect that are intertwined all the way along the process. So there's a keenness on the part of the Upper Tribunal and HMRC to establish a bright line demarcation. It's not obvious in practice that that would be the result of the test, because in many cases it's not clear where the physical aspect starts and the intellectual process ends. They are naturally part and parcel of the same process. In my skeleton, I gave the example of an item of plant being installed in a factory, where on the test that's put by the Upper Tribunal, the only thing that would count as installation is the physical process of turning the spanner, let's say, to install the bolts, and everything else before that wouldn't count. So preparatory acts such as deciding how best to affix the plant to the floor or setting up scaffolding and so on, that wouldn't count. But once all of that is done and the installer starts turning the spanner, that starts to qualify. But what if they encounter a problem while they're doing that and they have to think about it? Does it stop qualifying? And then it starts again once they've worked that out and they start turning the spanner again? That is, with respect to the Upper Tribunal and the Revenue, an unrealistic distinction for which there is no justification in principle or in the policy of the legislation. The reality of the matter is that all of these acts combine to affect the provision of the item in question. And as I've submitted, you can have items of plant on a scale of complexity, starting with the very simple, going to the very complex. Wind farm is at the more complex end of the spectrum, and designing and constructing and installing that out at sea is no mean feat. It requires an enormous amount of intellectual and physical effort to install it, and the how to do that is a critical part of the provision of it. Again, I wanted to, if I may, just briefly illustrate that by reference to the facts of one of the particular heads of expenditure, which is that relating to studies on archaeology, wrecks and cultural heritage sites. And what those studies do is identify the sites, finds of historic settlements, monuments, shipwrecks, lost aircraft and obstructions such as unexploded ordnance that might affect the construction of the wind farm. A number of issues were identified across the site as a result of these surveys, including identified and unidentified shipwrecks, downed aircraft, and sites of potential archaeological significance. The FTT made detailed findings about these measures at paragraph 179, which is internal page 43, it's PDF page 463.
Sorry, what paragraph?
It's 179,
Yeah.
and there are various subparagraphs dealing with the studies at the different sites.
Yeah.
That's 463 in my...
Yes, page 463, internal 43, paragraph 179.
Thank you.
Your PDF number is the electronic number, is it?
Yes, I'm sorry, I should
Yeah,
make
yes,
that clear.
Yeah.
I think the page number should be the same.
Really, I'm not using it electronically. I don't know whether
It is the same.
It is the same. Yes,
This one.
That's right. I thought you said 460 at one stage, but
I possibly did, I'm sorry.
it doesn't matter.
Yes.
So in terms of the various mitigation measures that are suggested as a result of the surveys, they are various. They include putting exclusion zones around the wreck sites, that's subparagraph 2, and subparagraph 3 and subparagraph 4. Pre-construction investigations, that's subparagraph 1, subparagraph 3, and minor adjustments to the locations of turbine foundations or the cable route, or failing that possible excavation, that's subparagraph 3 in the case of Walney. And at 180, which is on internal page 44, the FTT found that these studies directly related to the installation of the wind farm and its turbines. And this is over the page, onto the page, internal page 45. They directly relate to the installation of the wind farm since they're vital for safe installation. It would be disastrous for either a foot of the installation vessel or a foundation to be put down on the seabed at the site of an unexploded bomb. And one might also add to that that that's vital for the effective installation of the plant. Obviously, it wouldn't be usable if that eventuality was to happen. So the how to install aspect was critically important, and in my submission was clearly part of the process of installation, part of the provision of the plant. It went hand in hand with the physical process of hammering the monopiles into the seabed, ensuring that that was safe and effective. And there is no reason in principle or in policy in my submission for severing those parts of the installation process from the physical act of hammering it into the seabed.
So could one perhaps fairly characterise or paraphrase rather your concept of installation as really encompassing all the steps that are necessary in order to get the eventual plant functioning in situ?
Yes, I mean that is certainly a summary way. I mean, that in a sense.
I mean all steps, whether physical or, as you say, intellectual or.
Quite. I mean that is in a summary way. That is why installation expenditure qualifies.
Yeah.
As being within the scope of the legislation, because as my Lord Justice Zacaroli pointed to the part of Lord Reed's speech where he said, plant has to be installed in order for it to be used. So it's really part of that process. But a demarcation between physical and intellectual makes no sense. It is unreal. And if one is dealing in the coinage of the concept as it's set out in Urenco by way of SSE, it's described as a process which involves the integration. It doesn't comprise only the integration, it involves the integration. So it is part of it, but it's not all of it. And a process implies a series of steps, not just one thing. It's a series of steps.
You've got the word process from SSE. Does it really matter?
I don't. It may do. I mean, the point about SSE is that both sides are content to adopt that as a working definition of what the concept of installation means in this context. Now, and if one starts from that point, then yes, it matters. It's not critical to the point, but if one is going to start from that working definition, then in my submission, yes, it matters to understand what that means.
Yes, I mean, you say a series of steps. I mean, suppose you could do it in one step. Would that not be installation?
Well, it would be, but what I mean is that the concept of a process implies that it can accommodate something which is more than just hammering the thing into the ground. There are steps that have to take place before that can be done. And the definition, the working definition taken from SSE accommodates that in a way which is workable, principled, and realistic.
One sort of imagines that there must be not uncommonly cases where people employ a contractor to do something, and the contractor thinks about it and does it physically as well, and you pay the contractor, and nobody tries to split the physical from the intellectual.
Well, that's quite right, although one has to be slightly cautious with that, because although that's absolutely true, you can make the same case about design costs, which is that no one tries to strip those out, But that was the point that was made in Benedetto. No one tries to strip finance costs out if you buy the rig from the supplier of the rig and they've incurred finance costs. So one can only take that so far. But it is relevant to note in my submission that the Upper Tribunal recognises that the distinction that it has drawn in its decision does create a divergence between items of plant that are bought off the shelf and items of plant that have to be made from scratch. Because one would normally expect that as part of the costs of items of plant bought off the shelf, there are design costs in them. And on the Upper Tribunal's conclusion, the taxpayer who has to make the plant from scratch, incurring that design cost, wouldn't get allowances for that cost. And the Upper Tribunal accepts that there does not appear to be any policy reason for that distinction. Now, in my respectful submission, that rather indicates that there's a misstep in the logic of the Upper Tribunal. If you're recognising that there's a distinction of that kind, then it's rather like the distinction that seems to have driven a lot of the analysis in Benedetto. It suggests that something has gone wrong. And if one arrives at a construction and application of the legislation that has that effect, and there doesn't appear to be any purposive or policy reason for that, then it suggests that that analysis is incorrect.
Maybe that pass has already been sold in the recognition one finds in the case law, as you were saying. I mean, you can get your capital allowance if you pay an all-inclusive price, even though it does include preparatory steps, design, and probably an awful lot of other things, which one, in some instances, might be able to separate out.
Well, one can accept that if you arrive at a conclusion which has that effect, and there is no other way, because that's what the legislation says, then that is what Parliament can be taken to have intended. But where you're dealing with a situation where the words are capable of either construction, which is the case here in my submission, then a result that leads to that conclusion suggests that the result is wrong.
Well, you might say, conversely, the important thing is to encourage taxpayers to use more and perhaps more sophisticated, more up-to-date items of plant and machinery than they otherwise would without a tax incentive. In which case, the focus is much more on the incurring of the expenditure to end up with a particular end result, and you then have a right to deduct, without getting too pernickety about how you might, in theory, divide up the purchase price, how you've bought it off the shelf.
I'm not sure what conclusion that an identification of such a purpose would lead to. And in fact, there are instances within the capital allowances regime where Parliament seeks to incentivise the acquisition of particular things for particular reasons. So particularly environmentally friendly plant, for example, may attract a higher allowance. So where that purpose is present, it is usually identifiable from the quantum of the rate of allowances that Parliament has set. And that doesn't appear to be apparent in the provision that we are dealing with. So that is all I want to say about installation and the principles. I then wanted to turn to the decisions below, if I may. Starting with the FTT's decision. So the FTT began by setting out its reasoning and approach to what it considered to be the applicable principles. Within the decision, that starts at paragraph 113.
I'm sorry, FTT or Upper Tribunal?
I'm so sorry.
Are we FTT?
FTT, my lord, yep. Starting with the FTT, it's paragraph 113. It's page 442. Beginning with a discussion of the legal principles relevant to issue 2. So between 113 to 117, the FTT summarised the submissions. And then at 118 to 140, set out its reasoning and conclusions as to the principles. Some of them the appellants respectfully agree with, some of them they respectfully take issue with. Starting at 118, the FTT recognises that the sole question that it has to decide is whether the expenditure incurred on the studies and on project management is on the provision of plant. That is correct. And then at 121, the judge discusses the meaning of the word design, describing it as a weasel word, And then over the page, towards the end, about halfway through that paragraph, the judge says it's his instinct that there is a distinction between designs which go to the heart of the wind farm or the wind turbines, and without which, as Mr. Jones submits, it would not be possible to fabricate, install or construct the wind farm or the wind turbines to enable them to carry out their function of generating electricity, and those designs which do not go to the heart but are merely peripheral, and without them the wind farm and the wind turbines would still be able to carry out their function of generating electricity. Now that distinction was said by the tribunal to be based initially on its instinct, but then is said to be legally justified by what's said by Lord Reed and Lord Guest in Berkeley Curl, which uses, their speeches use the words must and also the word necessary. And that line of reasoning then led the FTT to draw a distinction, which is set out at 123 and 124, between what it called necessary design and unnecessary design. And necessary design is design without which the wind farms or wind turbines could not carry out that function, i.e. the function of generating electricity, and without which the wind farms or wind turbines would be operationally useless. And then unnecessary design, by contrast, is expenditure on design without which the wind farms or the wind turbines would not be operationally useless, and without which they'd continue to generate electricity, even if the amount of electricity is lower than might otherwise be the case if it were designed differently. And essentially, expenditure on necessary design was considered to qualify, and unnecessary design did not attract allowances. So that led the FTT to conclude at 125 that expenditure which directly relates to the necessary design of the wind turbines qualifies for allowances, and clarified at 138, which is on internal page 29. This is the third line. In the context of necessary design, it is only expenditure on studies which directly relate to the precise physical relationship between the wind farms at a particular wind farm site, which enables the wind turbines to function for the single purpose of generating electricity, which will qualify for allowances. So that was the test it was then applying. And just going back a step to internal page 27, paragraph 127, the FTT recognised that it had set a high bar for the appellants to get over. The FTT then makes some observations about design costs and considers briefly instances where design costs are built into the price paid for the plant bought off the shelf. And at 132, states that he sees no principled reason. Sorry, 131. I see no principled reason, therefore, why in the circumstances of these appeals, design costs which are necessary for the fabrication of the wind turbines should not qualify for allowances. As Mr. Jones observes, they are as necessary as the physical materials that go into the fabrication of the wind turbines. Now, as a standalone proposition, I respectfully submit that's entirely right. Reasons by extension from Berkeley Curl. The problem lies in elevating that to the proposition that only such costs can qualify for allowances. Looked at another way, it supposes that only costs which were necessarily incurred can be said to be on the provision of plant. And that is not part of the statutory requirements.
Just trying to understand the relationship between that submission and what I understood to be the key principle, what we took out of the submissions this morning, which was that what counts as expenditure without which the thing could not come into existence.
Well, that, yes. The point is that rather like in Berkeley Curl, the object of the exercise is not to define a touchstone for what will count in every single case. What happened in Berkeley Curl was that the special commissioners said the cost of excavation is too remote to qualify. And Lord Reed said, effectively, I'm not trying to define exactly where the boundary is, but where you have expenditure without which the thing can't be created, it must be the right side of the line. It cannot be too remote. So I'm not endeavouring to try and identify a principle that can be applied in every single case. I'm saying in the context of the expenditure that's in issue here, by extension of the same reasoning, it is on the right side of the line. But that is not to say that the only expenditure which can qualify is expenditure of that kind, which is what the FTT seems to have thought Berkeley Curl is saying.
Well, there may be a difference between that which was incurred by way of design, so the mental element, without which the thing that we actually have could not have come into existence. And the question of whether that design was necessary for it to function at all. There could be all sorts of aesthetic aspects of design which don't go to necessary as to function, but still you could say without that, this wouldn't be here.
Quite, and that was part of the difficulty with the test that the FTT had sought to introduce. So if you take an item of plant like the wind turbine that I showed you a picture of earlier, that has things on it like the gantry platforms, and it has lights, and it has colouring and stuff. If you say, let's identify the item, suppose we isolate that wind turbine, and we say what was expended on, what was the expenditure on the cost of providing that item, it would include the gantry, the ladders, the lights, and so on. And that's a perfectly legitimate cost in that context. But that doesn't involve asking whether it was necessary, in the same way that if one includes transportation costs, one doesn't ask whether you've booked the cheapest haulier in order to get the item transported to the site. The submission that I made to the Upper Tribunal was where Parliament requires that there be necessity in the expenditure, then it expressly says so. There's examples of that in the context of the Employment Tax Code, where deductions can only be allowed where the expenditure has been wholly, exclusively, and necessarily incurred. So where Parliament requires there to be necessity in the expenditure, it expressly says so, and it hasn't. So one doesn't, rather as was observed in Samarkand, one doesn't inquire into whether the money was well spent. And so the trouble with the FTT's test is that it seems to introduce a necessity requirement into the legislation which isn't there.
And this was something the FTT judge really came up of his own bat, is that right?
That's right. Neither side had sought to introduce that test.
Yes, and I'm not surprised to hear that. It's perhaps a little bold of him to go off on quite a big adventure of his own like that.
Well, the Upper Tribunal agreed that that was not part of the test, and nobody's seeking to reintroduce that. But it is important to understand the distinction that the FTT drew, because it then feeds into its reasoning and conclusions as you go on in the decision. Just picking it up, if I may, at 134. This is internal page 29, page 449 in the electronic version. The FTT expresses agreement that one must look back, as it were, when considering the statutory test, and provided the expenditure is on the provision of plant, then it does not matter that that expenditure was incurred long before the plant was provided. I respectfully agree and endorse that. And then at 135, similarly, I agree with me that there is no duality of purpose limitation. So the fact that some of the expenditure might have been incurred for more than one purpose doesn't prevent it from qualifying as expenditure on the provision of plant. Again, in my respectful submission, that is correct as a matter of principle.
So just to be clear, you don't attempt to apportion?
No. And then at 139, which is internal page 30, the FTT summarises the approach and states that the burden is on the taxpayer to show that were it not for the design, the wind farms and the wind turbines would not be able to carry out their function or purpose, namely the generation of electricity. And then at the final paragraph there, the FTT considered that the same sort of approach applied to expenditure on installation. It must go to the heart of the process of installation and directly relate to that. The essential elements of installation are that it should be undertaken safely and effectively, and only expenditure on studies that directly relate to those two elements of installation is allowable. And just in relation to that, in my submission, expenditure which is on installation of the plant is qualifying, not just in relation to those two elements, but I don't take issue with the FTT's conclusions on installation expenditure. So
Sorry, you don't take issue with their conclusions on installation expenditure. You mean as they apply?
Yes, as they apply that test. I mean,
Yes.
Certainly one might debate whether safe installation is a relevant consideration, but it's difficult to say that ensuring that the installation is effective shouldn't qualify, because the whole point of installation qualifying is that it results in the effect that the plant has provided. So ensuring that that takes place effectively is surely part and parcel of why the installation costs qualify in the first place. So it's quite difficult in my submission to quibble with the idea that ensuring it's effective is part of that cost of provision. So armed with those principles, the FTT then went on to find further specific facts in respect of the surveys and studies and reached its conclusions on each head of expenditure. So there is much in there that the appellants respectfully agree with, and some aspects with which the appellants respectfully take issue. Essentially, the main criticism is that the curve that was drawn by the FTT was too narrow. So essentially, everything that it found to be within its curve, in my respectful submission, is properly qualifying. But the FTT did exclude expenditure which is also qualifying. And there are two main errors in relation to that, in my respectful submission. The first is this necessary-unnecessary design distinction, which I've already addressed your lordships on, and which the Upper Tribunal identified as an error in its decision at 119121, and again at paragraph 1751.
Sorry, that was which paragraphs?
It's at 119 to 121 of the Upper Tribunal's decision,
Yeah.
and also 175, subparagraph 1.
Yeah.
The second error, and this links to a point made in my skeleton at paragraph 22, is that the FTT applied an overly restrictive approach to identifying which studies and aspects of the studies were related to the design of the wind farm and the wind turbines. In short, the FTT drew a distinction between expenditure which resulted in a change of design and expenditure which didn't, either because the data from the survey confirmed existing design parameters, or because the survey revealed that there was no issue. And the FTT accepted that instances where the input would change a design qualified, but held that the second type didn't go to design.
So if you found a bomb, then it counted, but if you didn't, it didn't.
Quite. Or if, and to take another specific example, there were ornithological and collision risk surveys that looked at the migrating bird populations and also the resident bird populations. And one of the aspects of those studies involved looking to see whether the turbine heights had to be adjusted to ensure that there wasn't a collision risk. And the FTT notes, this is paragraph 174, that there was evidence that in 2 of the wind farms that were not within the scope of these appeals, the collision risk surveys had identified that there was an issue and the turbine heights had to move as a result. But the judge went on to decide that because the studies in respect of the 4 wind farm sites in issue did not result in a change to the turbine heights because it was decided there was not a problem that required that adjustment, then that didn't qualify. It didn't form part of the expenditure on the design. With respect to the FTT, that's a logical misstep, essentially for the reason that's identified by Lord Justice Newey in relation to the unexploded bomb. Checking whether there's an issue is just as valuable and is just as much an input into the process, whether you find out there is an issue or you find out that there isn't one. Confirming a design parameter is still an input into design. So confirmatory data is just as much a contribution to design as data which requires or suggests a change. Now, the FTT seems to have acknowledged that proposition to some extent. If your lordships have the FTT's decision at 153, this is page 453, internal page 33. The FTT reiterates what it's looking for, and then at 154 says, in my view, it doesn't mean that there will necessarily be a direct and obvious correlation between the study on the one hand and a change to that necessary design when tested against a previous design on the other, as in Mr. McCarley's example of low-flying birds and increasing tower height. Nor does there need to be. There might be such direct correlation, but the oral evidence is that the data which is derived from the studies is used to inform the ongoing computer modelling of the design of the wind farms and all the wind turbines. So whilst a great deal of data will be inputted into the modelling, its impact might be negligible since it's outweighed by the greater impact of the other data. But this doesn't mean that it does not directly relate to the necessary design of the wind farm and all the turbines, provided the appellant can show that the data was taken into account in that modelling, which resulted in the necessary design of the wind farm and all the wind turbines and all their safe and effective installation, then it is to my mind directly related to that design and installation, even if there was no obvious change to the evolving designs of the wind farm and all the wind turbines as a result of the input of that data. As Mr. McCarley stated in his evidence, if the data confirms the assumptions which have been made in a particular model or version of that model, then that model will not change, but the data still directly relates to the design set out in that model. So that appears to acknowledge the proposition that input which confirms a design is still directly related to the design. But then in the next paragraph, the FTT says, however, the appellant needs to do more than simply show that a data from the study was considered as part of the EIA. Each EIA is structured in a similar manner. For each study, it identifies the impact on the design, construction, operation, and decommissioning of the wind farm, and on occasions the impact on the design, construction and installation of the wind turbines. It then goes on to propose mitigation measures which might be appropriate to mitigate the impact which it has identified. It's difficult for me to see how the data of any study which identifies impacts but then proposes no mitigation measures would have been inputted into the model. I cannot see how that data will have any impact, however iterative or indirect, on the modelling and thus on the design and construction of the wind farm and the wind turbines. So when considering these studies, I'll be concentrating on the mitigation measures. Now that, in my submission, is too narrow a view and meant that the FTT discounted matters that were relevant inputs into design. That's all I want to say at this stage about the FTT's decision. I was going to turn next to the Upper Tribunal decision. Now, the UT's consideration of this issue is found in paragraph 75 to 182. with discussion of the principles to be applied found at 110 to 174. And at 138, starting at 143, this is internal page 24. The Upper Tribunal by this stage has considered Berkeley, Curl and Benedetto. And at 143 states that, in its view, the result in real terms is a strict and narrow application of the statutory words. The taxpayer relies on various other authorities to show, in essence, a wider test. We do not agree that they do. I'll come to that in a moment. But at 138, internal page 22, the Upper Tribunal referred to the analogy between expenditure on the construction of a building and expenditure on the provision of the plan, and took that as a useful, although not determinative, guide, but concluded that the sense that one gets from that analogy, and this is at the end of paragraph 138, is that the focus is on what it describes as doing and making, rather than advice on doing and making. And then as regards installation costs, this is at paragraph 156, internal page 26. The tribunal refers with apparent approval to the description of the concept of installation in Urenco, and then says, however, there is no reason to suppose, this is at the end of 156, there's no reason to suppose that physical process encompassed the intellectual effort entailed in planning and advising on how and when the installation activity should be carried out. And then in the following paragraph, the tribunal drew a distinction, in the final part of that paragraph, between advice or expenditure on advice which puts the taxpayer in the position of being able to install the plant. Contrast that with expenditure on the provision of plant in the form of the installation of the plant. And then as regards design costs, which it deals with in the next section, the Upper Tribunal in 164 draws a similar distinction to the one it draws in 156 between expenditure which puts the taxpayer in the position to provide plant. It's at the end of 164. Provision of plant is what happens when those designs are turned into the plant. And then at 165, stated that, in its view, to provide plant, this is the second line, to provide plant assumes that there is already some notion of the plant in respect of which provision becomes relevant. As we've explained, provision is focused on the cost of doing, making or constructing. The intellectual effort which goes into the design process may be instrumental to conceiving of what the plant is, conceiving of what the plant that is to be made or constructed is, but it appears odd to refer to the design of the plant, which is something which happens when the final form and shape of the plant is still to be determined, as the provision of the plant, which assumes the plant is final, such that it can be provided. And then the Upper Tribunal goes on in 167 to test that reasoning by comparing it to the notion of expenditure on the construction of a building, and concludes that while the design process is a precursor to construction, we consider it would be odd to refer to the intellectual activity of designing a building as the physical process of constructing it. And based on those lines of reasoning, the Upper Tribunal concluded that the FTT erred in law. This is at paragraph 175, internal page 29, and that it erred in law in a number of respects. Looking at those specifically, the first point is that the FTT's test of necessity was wrong, as was the position of both parties before the Upper Tribunal. The Upper Tribunal also decides that the FTT's test of directly related was wrong. Now, the appellants didn't actually take issue with that aspect of what the FTT was saying, and in my submission, there is a fair grounding for analysing the position in terms of that sort of concept based on what Lord Wilberforce said in his speech in Benedetto, that the UK statute focuses on the plant and expenditure directly related to the plant. But of course, with many of these things, that is also a gloss on the statutory wording. In subparagraph 2, the tribunal concluded that the FTT had erred in developing a specific test for design when the correct approach would be to keep focus on whether the expenditure was on the provision of plant. Now, as to that, the FTT clearly viewed expenditure on the design of the plant as being expenditure on the provision of plant, although it introduced its necessary, unnecessary qualifier to that. With respect to the Upper Tribunal, the FTT didn't lose focus on the statutory words. In fact, as I showed you, Lordships, a few minutes ago, the FTT said, the sole question I have to decide is whether this expenditure was expenditure on the provision of plant within the statutory wording. The difference between the tribunals was, in essence, that the FTT considered that the expenditure on the design was part of the cost of provision, and the Upper Tribunal did not. In my submission, the FTT was right on that, but it's not right to say that the FTT lost sight of the overall task. It had that well in mind. Thirdly, the Upper Tribunal concludes that the FTT was wrong to consider that the disparity between purchase with design built into the price and design by the taxpayer meant design costs would qualify. As I submitted in response to a point that was made, I think, by my Lord Justice Newey in relation to design costs in off-the-shelf items, it is a relevant consideration. It's not determinative, but it is a relevant consideration for the reasons that I endeavour to explain. And the Upper Tribunal itself, as I've mentioned, noted, and this is paragraph 168, internal page 28, recognised that there isn't a stripping out of design costs from items bought off the shelf, and then states in the fourth line, at the level of policy, we recognise the taxpayer's point that this gives rise to a disparity in treatment without an obvious policy justification between expenditure on design activities incorporated into a sale price and those which are undertaken by the taxpayer, which will be a common feature in large-scale projects involving bespoke plant. But then notes the point from Benedetto that simply identifying that doesn't win the day. Now that is fair enough, but as I've submitted, the existence of that disparity without an obvious justification anywhere strongly tend to indicate that the analysis has gone wrong. And just going back to 175, subparagraph 4, dealing with installation, the Upper Tribunal concluded that the FTT was wrong to adopt a safe and effective installation test. The test, again, was whether the expenditure was on installation, recognising that was not a term of art, but simply something case law acknowledged could fall within on the provision of. And again, this is then resonates with the submission that I made earlier. if one accepts, and one must, as the law stands, that installation counts as being part of the cost of provision, then it is a fair exercise to undertake to try and understand the bounds of that concept, albeit it's judicially made and is not one that expressly stands on the face of the legislation. The FTT didn't lose sight of the fact that what it had to do was decide whether the costs in issue fell within the statutory wording. That's 118 of the FTT's decision. What the FTT considered, in my submission correctly, was that expenditure on ensuring the installation was safe and effective was part of the cost of installation and was qualifying expenditure within the statutory words. So in terms of the Upper Tribunal's next steps, it decided to remake the decision. This is then set out in its decision, paragraph 178 onwards. And the effect of it at the end was that none of the expenditure that remained in dispute following the Upper Tribunal's decision, following the FTT's decision, was considered to be qualifying. The appellants submit with respect to the Upper Tribunal that it erred in law in arriving at that conclusion, and there are 5 headline points.
And just before you get there, do you accept that the UT had to remake the decision?
Well, having decided that there were those errors.
And while you may take issue with some of what the Upper Tribunal said in paragraph 175, you don't take issue with all of it, so you accept that the FTT went wrong, and therefore the Upper Tribunal had to make its own decision.
Well, both parties argued before the Upper Tribunal that the FTT had erred in law in relation to its necessary, unnecessary design distinction.
Yeah.
That was an error of law. It's then within the discretion of the Upper Tribunal as to whether it remakes it, what it does in response to that. But if the question is,
yes,
having found that, was it open to the Upper Tribunal to remake it? The answer has to be yes.
Yes.
But in the course of remaking it, as I'll endeavour to explain now, the Upper Tribunal fell into error in applying mission wrong in law. There are 5 main points to this. It tracks the points that are made in the skeleton that support the grounds of appeal. First point is that the Upper Tribunal's construction of the statute is unduly restrictive. Now, as I showed you, Lordships, at 143, the Upper Tribunal concluded that the statutory wording should have a strict and narrow application. And that was said by the Upper Tribunal to follow from points that it had summarised at paragraph 140 from Barclay, Curl and Benedetto. Just looking at those points, the first and second points are ones that the appellants respectfully agree with. The first part of the third point in my submission is correct. The contrary would be too sweeping a proposition. The second part, as I've submitted, has some support in the authorities, but as I've also submitted, one has to handle that with care in terms of whether it can really serve a function as an analytical tool. It can help in the analysis, but it's not itself a test. And then as to the fourth point, again, I've already made some submissions on that. It's fine as far as it goes, but where the Upper Tribunal's interpretation of the statute gives rise to a discrepancy in treatment, it doesn't appear to have any justification. Then that calls into question whether that interpretation is correct.
Can we just skip back to the first part of 3 again? You say that's too wide.
That is too wide.
You say it's too... Is that because of the emphasis on the taxpayer?
Yes, exactly.
Yes.
Because I'm no doubt, in fact, I think these were the facts of Benedetto, the taxpayer had to borrow that money. But as I endeavoured to explain this morning, oil rigs can be purchased without incurring loan finance.
So in your case, that sentence, you say it is the case that any expenditure that needed to be incurred in order for the plant to be provided is allowed.
Yes.
Yeah.
But that's different from saying it had to be incurred by the taxpayer.
Yes.
That's the emphasis on the subjectivity that Benedetto says would be problematic.
Yes.
But looking at all those points, they don't, with respect, justify the conclusion of the Upper Tribunal at 143 that the statutory words require a strict and narrow application. Now, it is true to say that the majority speeches in Benedetto tend towards a narrower rather than a more generous interpretation. But as I've submitted, what seems to have played an important role in the outcome of that case was the concern about the disparity. And in fact, there is an indication in Lord Reed's speech in Berkeley Curl, right at the end, the point that I emphasised, that if one takes as an analogy or an equivalent expenditure on the construction of a building, Lord Reed says it looks like those were intended to be wide words. But really, the question isn't whether one takes a strict or a generous approach. The question is simply what falls within the scope of the words properly construed. But even if one says there's a strict meaning, what the Upper Tribunal did wasn't just apply a strict meaning, it applied a restrictive meaning that wasn't required by the wording or the purpose of the legislation. And it led the tribunal to draw distinctions which, with respect, don't have any grounding in logical principle. So, for example, the insistence on drawing a demarcation line between design and physical fabrication, or in the context of installation, drawing a distinction between a physical act of integrating one asset into another and the intellectual precursor to that, or even the intellectual aspect that goes hand in hand with that at the same time. So that's the first point. The Upper Tribunal's approach is unduly restrictive. The second point is that its construction and its analysis is not consistent with prior authority. There's the distinction that lies at the heart of the Upper Tribunal's reasoning between expenditure on the provision of plant and expenditure which can be described as only putting one into the position to provide plant. That was at 164. And then a similar distinction is drawn by the Upper Tribunal in the context of installation. Advice that puts you in the position of being able to install plant doesn't qualify. And with respect to the Upper Tribunal, that distinction is a false one, and in my submission is inconsistent with the decision in Berkeley Curl. As I sought to highlight when we looked at that this morning, the expenditure on the excavation was preliminary, it was preparatory. The special commissioners had denied it as qualifying expenditure on the basis that it was expenditure on the preparation of land to receive the machinery or plant. And it was described as a preliminary excavation cost by Lord Reed and a necessary preliminary by Lord Guest. So, in other words, the expenditure on excavation was expenditure that put the taxpayer in the position to have the dry dock constructed. The excavation wasn't itself plant, and the excavation itself didn't provide plant. But applying the Upper Tribunal's distinction, that expenditure should not have qualified. And yet the House of Lords considered that it did. as I mentioned this morning, the Upper Tribunal and HMRC appear with respect to have misinterpreted Barclay-Curl in this respect, because they describe, this is Upper Tribunal at 120, they describe that the essence of Lord Reid's reasoning was that without the excavation, the plant could not be said to have been provided. The provision of the plant was incoherent or incomplete, which appears to be a suggestion that somehow the excavation completed the dry dock. If anything, it's the opposite way round. It was required as a prior step before the plant could be constructed. Lord Reid described it as the cost of making room for the dry dock, and said it couldn't even be made until the necessary excavating had been done.
And you gave us paragraph reference as a paragraph reference for that, but I didn't get it.
In the Upper Tribunal.
In the Upper Tribunal.
It's
paragraph 120.
It's 120.
Yeah.
So it wasn't the case on the facts of Barclay-Curl that the excavation made the plant cohate, as the Upper Tribunal said. It was the other end of the process. It was before construction could begin. And that is also how the Court of Appeal in the Cheshire Cavity Storage case appears to have understood that part of Lord Reid's speech. If I could very briefly show you that passage. It's in the Authorities Bundle, Volume 2, tab 25. Page 467.
Sorry, which tab are we at?
Tab 25.
Thank you.
And within that, it's paragraph 36, so that should be page 467. Now, this case was about whether cavities that had a specific function could qualify as planned. But there was a consideration in detail of Barclay-Curl. And the part that I just refer to specifically is in paragraph 36. In our case, the cavity is impound gas, which the taxpayers use as a source of the gas with which they trade. Thus far in the consideration of Barclay-Curl, Lord Reid was dealing with the cost of lining the excavation, which was the installation of a man-made structure into a specifically prepared setting. What about the cost of excavation itself? Lord Reid held that the cost of the excavation did qualify, but it is important to understand why. And then there's an extract from Lord Reid's speech that refers to the necessary excavating. And then at 37, Lord Justice Lewison says, as I read this, the cost of excavating the dock, if it stood alone, would not have qualified as planned. It was because the excavation was necessary before the plant was installed that it was qualifying expenditure. So in my submission, the distinction drawn by the Upper Tribunal is inconsistent with what happened in Barclay-Curl, the reasoning and the result. The excavation expenditure could properly be described as expenditure that put the taxpayer in the position to provide the plant.
Just to be clear, you're taking issue here with the suggested distinction between providing the plant and putting yourself in a position to provide the plant.
Yes.
I mean, just glancing on at Lord Justice Lewison, does he perhaps treat the excavation as integral to the provision of the dock, which might suggest that the distinction could be sustained? I mean, I'm just glancing on to paragraph 40 and paragraph 44, or paragraph 45. Well, for example, paragraph 44. So yet again, the expenditure on excavation qualifies only because it is part of a whole, which includes the machinery necessary for the dry dock operation. 40, the whole ensemble, including the dock itself, had to be seen as an integral whole. 44, once completed, the dry dock was to be treated as an integral whole. I don't think he's just referring to the dry dock and the machinery in it, so to speak. He seems to be encompassing the excavation.
It's absolutely right that it qualifies because it's part of the provision of the plant. And that in itself, it's once one knows the results, it's self-evident. But the point is that one can properly describe that expenditure as expenditure which put Berkeley Curl in the position to have the plant provided, because the hole itself wasn't planned. And on the Upper Tribunal's tests, that should fail. That's the point that I'm driving at. The distinction that is drawn is inconsistent even with Berkeley Curl. But that isn't the only inconsistency that one can see on the authorities, because there's also the category of expenditure that is accepted as qualifying, which is called preliminaries, or preliminary expenditure, which is its own category. And there's a convenient description of the concept of preliminaries given by the Upper Tribunal in the Wetherspoon case, which is in the authorities bundle at tab 21, so it's volume 2. So volume 2, tab 21, it's PDF page 328. And the case concerned a dispute between JD, Wetherspoon and HMRC about various claims for capital allowances for expenditure on the fitting out and refurbishment of various pubs. The dispute covered a number of different points, one of which concerned the apportionment of preliminary costs. The Special Commissioners had decided that a pro rata apportionment was reasonable, pro rata in the sense of being apportioned by reference to the amount of works that were allowable for capital allowances purposes. HMRC challenged that aspect of the decision. Consideration of this part of the appeal begins at paragraph 92, which is on 352. And there's a definition given by the Upper Tribunal. Preliminaries are by their nature items of overhead expenditure which cannot be, or which have not been, attributed to any single item in the building project. Some, like insurance, are inherently incapable of being so attributed. Others, like scaffolding, may be capable of specific attribution, but the time and cost involved in the process of specific attribution is often disproportionate to the amount at stake. Thus, apportionment of preliminaries between items which do and do not qualify for capital allowances is the only solution in relation to unattributable preliminaries, and may be the sensible solution where attribution is uneconomic. Now, those examples, scaffolding, insurance, they aren't planned for the person who is commissioning the building project. Insurance isn't planned for anybody, nor do they amount to the physical installation of plant. They are purely preparatory or preliminary, as the name suggests, but they're nevertheless within the scope of section 11 sub 4, as HMRC accept and continue to accept. And in fact, HMRC give other examples. In the authorities bundle, that's 621, there's an extract from one of the Revenue's Capital Allowances manuals. It's tab 30 in volume 2. So there it's dealing with plant and machinery allowances, professional fees and preliminaries. Professional fees such as survey fees, architects' fees, quantity surveyors' fees, structural engineers' fees, service engineers' fees, or legal costs only qualify for plant and machinery allowances as expenditure on the provision of plant or machinery if they relate directly to the acquisition, transport and installation of the plant or machinery, and as such are part of the expenditure incurred on the provision of the plant or machinery. The same rule of law applies to preliminaries. Preliminaries are indirect costs incurred over the duration of a project on items such as site management, insurance, general purpose labour, temporary accommodation and security. Where preliminaries and professional fees are paid in connection with a building project that includes the provision of plant or machinery, only the part, if any, which relates to the services that can properly be regarded as on the provision of plant or machinery can be qualifying expenditure for PMA. Establishing that part which relates to such services needs to be determined on a case-by-case basis. And then there's a reference to apportioning. And then there's a reference to the description of preliminaries in paragraph 92 of Wetherspoon. So there's acceptance in published guidance that professional fees incurred prior to the installation of plant or machinery, such as survey fees and architect's fees, may form part of the expenditure incurred on the provision of plant or machinery. Now, of course, this is HMRC's manual. This is not the law. But HMRC don't shrink from that statement in these proceedings. In my learned friend's skeleton, page 12, footnote 12, he suggests that there is no inconsistency with their case, between their case and what's said there. With respect, it is difficult to see how that is so. They seek to support what the Upper Tribunal has done and the distinctions that the Upper Tribunal has drawn. But all, or at least most, of the professional fees referred to there surely relate to intellectual work, including preliminary surveys and design work, not the physical acts of making the plant. Yet HMRC seek to uphold the Upper Tribunal's decision, which would seem to cut across that. Moreover, the statement that costs qualify if they relate directly to the acquisition, transport and installation of the plant is one they appear now to disavow. It is difficult to see how the Upper Tribunal's conclusion that expenditure which only puts the taxpayer in the position to provide plant cannot be qualifying can sit consistently with the accepted recognition of preliminary costs as items that qualify within the scope of section 11.4. Indeed, the Upper Tribunal's decision seems to remove preliminaries as a qualifying item altogether. That was the third point, inconsistency with existing items on the map of this area of the law, including Berkeley Curl. The third point concerns the analogy with expenditure on the construction of a building. I've shown you, Lordships, the source of the basis for that analogy. The Upper Tribunal recognised that such an analogy can be drawn correctly in my submission. That's at paragraph 138. I'd also respectfully agree with what the Upper Tribunal says in terms of it's not determinative, but it is a useful guide. The trouble is the way in which the Upper Tribunal then approaches that, and its conclusion at the end of 138, that the clear sense from the comparison is a focus on doing and making rather than advice on doing and making. And in my submission, that's an error. In the context of constructing a building and of providing plant which needs to be constructed, a distinction between doing and making on the one hand and advice on doing and making on the other is artificial and it's unrealistic. Buildings are rarely built without plans. A process of construction is iterative. The how and the what to do are as fundamental as the process of putting one brick on top of another. It's also not clear why the work of people like architects isn't doing in this case. At 165 in the decision, this is internal page 28, the Upper Tribunal returns to this and refers to providing plant, it assumes that there is already some notion of plant in respect of which the provision becomes relevant. And as we've explained, provision is focused on the cost of doing, making, or constructing. Intellectual effort which goes to the design process may be instrumental to conceiving of what the plant that is to be made or constructed is, but it appears odd to refer to the design of the plant, which is something happened when the final form and shape of the plant is still to be determined, as the provision of the plant, which assumes the plant is final such that it can be provided. And then that's also reflected in 167. But there is nothing odd about including the costs of designing the building to be constructed as part of the expenditure on the construction of the building. On the contrary, it seems rather odd to exclude that expenditure. It seems rather artificial to try and separate the intellectual process from the physical aspect. One would naturally, in my submission, regard the costs of drawing up plans for the building as part of the construction of the building. And HMRC themselves acknowledge that too in their Capital Allowances Manual. It's in the authorities bundle at page 624.
That's the architect's fees.
Quite, yes, exactly. I think that's the final entry in the authorities bundle in volume 2. It's page 624, where HMRC explained that expenditure treated as incurred on the construction of a building includes professional fees relating to the design and construction of a building, provided that the building is actually constructed. In my submission, seems like an absolutely fair point.
So just to be clear, if you want to build a building and you get architect's drawings and you make an application for planning permission and the application succeeds and then you go ahead and build a building, you can put down all those costs, I mean the architect's fees and the planning permission application costs.
I think the cost of obtaining planning permission is specifically carved out in that particular code. But in terms of the architect's fees, which is what we are concerned with here for the purposes of the analogy with design, they are considered to be qualifying. Provided the building is built, which of course makes sense, because if one is looking at plant which has in fact been provided and one looks back down the track to see what it costs to provide that, the cost of designing it is absolutely part of that. Now, HMRC's response to this point is not to deny the analogy drawn by the Upper Tribunal between expenditure on construction of a building and expenditure on the provision of plans. They appear to accept that. Nor is it to say that design costs are not part of expenditure incurred on the construction of a building. They don't seek to contradict what's said in their manual. What they say is that that part of the manual is concerned with a different bit of the 2001 Act. It's concerned with what are called structures and buildings allowances. But with respect, that doesn't detract from the point, because the relevant part of the Act refers to expenditure incurred on the construction of a building or structure. The same words are used in that part of the Act. It's materially the same wording as that which Mr. Justice Brightman and Lord Donovan had in mind when drawing the analogy. So the analogy holds good in my submission. And what the revenue recognised there is absolutely right. So that was the third point. The fourth of the 5 points deals with what the Upper Tribunal says in 165, another aspect of what they say in 165, which is to say that the provision of plant assumes that the plant is in final form such that it can be provided. That seems to suggest that one can't have expenditure on the provision of the plant unless and until the plant is in final form. But if that is the conclusion, then it's wrong in law and appears again to be inconsistent with the authorities. It's going back to Berkeley Curl, the digging of the hole was done at a time before the dry dock was in final form. For all the reasons that I've given. Likewise, expenditures on preliminaries They qualify before the thing has been constructed or installed.
Is that the point that's being made? Going back to the second sentence of that paragraph, to provide plant assumes that there is already some notion of the plant. Is it enough that there's a notion of the plant?
If, my lord, reading on though, the intellectual effort that goes into the design process may be instrumental to conceiving of what the plant that is to be made or constructed is, but it appears odd to refer to the design of the plant, which is something which happens when the final form and shape of the plant is still to be determined, as the provision of the plant, which assumes the plant is final, such that it can be provided. It's the final bit of that paragraph that seems to imply that you need to have the plant in final form so that it can be provided.
But that can't be right, because it's talking about constructing plant as well as purchasing it.
Well, it's difficult to see what else is meant by that aspect of the reasoning.
I mean, you'd say it's still wrong, but the supposing it means what the earlier sentence suggests, there has to be a notion of the plant. You already have to know what it is you're going to provide. Now that would work with Berkeley Curl, because you know you're going to put in the dry dock, that's why you're digging the hole. I don't know whether it would necessarily work with the building cases.
But it certainly works in this case, because the appellants didn't turn up to the site and wonder what they might put there. They knew that they were going to install a wind farm if they went ahead with the project.
I suppose it depends on what degree of specificity you're talking about. You knew you wanted a wind farm if you were going to go ahead, but you didn't know what the wind farm was going to be. You didn't have a precise picture of your wind farm.
Yes.
I suppose that's where you put in the planning application in the hope that that one might be approved, but then the planning authorities say it has to be a bit different.
Well, first of all, why is that even a requirement of the legislation? Why, if one examines then what level of specificity is needed, one needs some sort of guidance. The legislation doesn't imply that that is a requirement. The legislation starts from the assumption that plant has been provided, so it is already done.
I mean, that's really the appropriate control, isn't it? I mean, none of this gets off the ground if you don't actually, at the end of the day, have a piece of plant and machinery in situ,
Precisely,
functioning in your trade.
Precisely.
And if you do have that, then you look back retrospectively and see what is the process which has led to that end result.
I entirely agree, my lord, with respect. And so one necessarily is starting from the position that the plant has been provided. But it's difficult to see what role this requirement for it to be in final form or sufficiently final form is playing. I mean, if it is right, and it is recognised in the House of Lords, that you can qualify for allowances in relation to plant that has to be constructed as opposed to purchased off the shelf, and the Upper Tribunal accepts that, so it then cannot be right to focus only on the point at which the item has been created, or it's in sufficiently final form that you can say it's been provided, whatever that means. And then it's within this part of the Upper Tribunal's decision that it deals with the company's reliance on McVeigh, the case that I showed your lordships earlier about the wooden blocks being carved in a certain way in order to produce patterns on wallpaper. And as I submitted when we were looking at that authority, the Upper Tribunal seems to have read the facts of that case. It didn't have the Special Commissioner's decision at that time, it's fair to say. It seems to have understood the facts of that case as being that the designs completed the wooden blocks in a physical sense. We say that the designs made the blocks cohate as an item of plant. This is at 171. Although the case refers to design, the specific and different sense in which that term arose is relevant. The designs, the patterns, were used to complete the plant, i.e. the wooden block, not to design, emphasis, the wooden block. The designs were part of making the wooden block function as a wall patterning block. The revenue had conceded the blocks would be incohate plant without the patterns on them. And as I've endeavoured to explain this morning, that is not quite the facts of McVeigh. They were design inputs in a conceptual sense. So they absolutely were used to design the wooden block. And then there's the point at 172 about Daphne and Shaw. You have my submissions on that as to why that particular fact does not infect in any way or undermine the reasoning of the High Court in McVeigh. Nor, with respect, is it correct to say in 173 there was no specific reasoning given for the High Court's conclusion. It's fair to say the conclusion is compressed, but as I submitted when we were looking at the case, one might say the same about Benedetto. Ultimately, these are not points that, in the end, admit of great elaboration. Your Lordships might disagree with that, having heard a day of submissions on the point. But ultimately, it's a question of which side of the line this falls on.
Yeah.
It's good to know at least we can use very short judgment.
So that was the fourth point. And then the fifth point, the fifth error, concerns the installation costs and the Upper Tribunal's treatment of those. Now, the conclusions of the Upper Tribunal on that are at 154 to 158. And as I submitted earlier, the Upper Tribunal appears to have accepted that it was useful to approach the concept of installation in this context along the lines of those suggested in Urenco, but then says at 156, the process that's referred to is one of the physical activity of integration of one thing into another in contradistinction to the manufacture of the plant or the act of putting a completed item of plant into place. There is no reason to suppose that physical process encompassed the intellectual effort entailed in planning and advising how and when the installation activity should be carried out. And then again at 157, it's this distinction between putting the taxpayer in a position to have the plant installed versus expenditure on the provision of plant in the form of installation. So again, there's that echo of the distinction that's drawn between preliminary preparatory expenditure, which the Upper Tribunal seems to think does not count, and expenditure on the provision of. Your Lordships already have my submissions on why it's an error of principle to try and disaggregate the intellectual part of a process of installation from the physical part of the process. Now, that was all I was proposing to say about the Upper Tribunal's decision and why I submit that it erred in law in reaching its conclusions. In terms of what the appellants would respectfully invite this court to do, it is to reverse the Upper Tribunal's decision and to hold that, as a matter of principle, the costs of designing items of plant, including the costs of obtaining inputs into that design process, are capable of qualifying as expenditure on the provision of the plant in question, as the FTT held. And for the reasons I've given, I'd also respectfully invite the court to hold that, as a matter of principle, inputs which confirm existing designs or assumptions, as well as those which lead to changes in design, both qualify in that regard. And in addition to that, as a matter of principle, for the reasons that I have given, to hold that expenditure on advice as to how and when to install the plant, so as to ensure safe and effective installation, is also capable of qualifying as expenditure on the provision of plant, as the FTT held. Now, there are, of course, specific heads of expenditure that are in issue that have been tested by the FTT. In my skeleton argument to the court, I did say that if I was invited to do so, I would address each head of expenditure that remains in issue. Alternatively, the court might prefer to give a decision in principle and then invite the parties to seek to agree the outcome as regards the expenditure on the basis of that decision. Of course, there are other consequential matters that fall from that. So I'm really in the court's hands as to how...
how are we doing on time?
well,
You did agree a timetable.
Yes.
Which I think left some time for reply. I can't remember on that basis when you're due to sit down tomorrow morning.
I had thought that I would try and sit down at about 11:30 to leave myself some time for reply. Now, being frank, it will take some time to go through the different heads of expenditure.
Yes.
And I can also see that that might be unnecessary in light of the decision. It might also be the case that the court arrives at a decision which is different from that arrived at from both the FTT and the Upper Tribunal, which means that different principles have to be applied to those facts. So it may be...
I think at least for tonight, let's leave it and make sure we get your submissions on the other issues.
I'm grateful for that, my lord. It's now 5-4. I was going to move, in that case, to ground 2 and the revenue expenditure
Yes.
issue. I'm happy to carry on with that now, or happy to start.
I thought we might as well carry on.
I'm grateful.
Do we detect a lack of confidence in the ground in that it comes second? Because it gives you more than the first ground, doesn't it?
No, that is not, with respect, that's not the way that it is put. The company's primary position is that the expenditure was capital expenditure, and it was capital expenditure because it was expenditure on the acquisition of a capital asset, which is the wind farm.
Yeah.
And under the established case law principles, the working assumption is that that would render the expenditure capital. So that's the company's primary position. On the case law that I'll show you, lordships, in a moment, if there isn't a capital asset that could be said to have been acquired or modified as a result of the expenditure, then the working assumption would be that it was revenue. Now, given the relationship and the similarity between the concept of expenditure on the acquisition of an asset and expenditure on the provision of an asset, the case basically goes hand in hand with issue 2. But if this is not expenditure on the acquisition of a wind farm, then query how else it could be capital. There is also the point that if HMRC are right and the Upper Tribunal is right, then these appellants have incurred large amounts of expenditure to create an offshore wind farm which is then used to generate electricity that they sell for the purposes of their trade to generate trading profits. And yet they will get no deduction of any kind for the expenditure in question here.
I mean, that's just inherent in the basic prohibition on the deduction of capital expenditure and the computation of trading profits, isn't it? Assuming we get to this point.
Well, that would be that might be the consequence of, well, that would be the consequence of the outcome.
Yeah.
But it does appear rather odd that one could incur all of that expenditure in that way for that purpose.
Well, I'm not sure it is odd, is it? Once you, I mean, given that the underlying position has been for, I mean, absolutely ages, that capital expenditure is not deductible, and that's why we have the whole law of capital allowances in the first place. So you get, that's how you normally get round the absence of an allowable deduction for capital expenditure on the expense you incur in the course of your trade.
Well, I don't disagree with any of that. But
So it's not really odd in any objective sense, is it? It might seem sort of a bit unfair and maybe somewhere in a kind of area where one might lobby for further reform or for widening of the capital allowance regime. But the basic starting point is it's only revenue expenditure you can deduct in computing revenue profits.
I don't disagree with any of that. I mean, and I don't say it drives the analysis in any way that would be the conclusion. But it would be the conclusion if the Upper Tribunal and HMRC are right in the way they say that this works. So it is the revenue, it is the company's primary position that the expenditure in question is capital for the reason that it's expenditure on the provision of or the acquisition of a wind farm. Now, the statutory basis for this is Section 61 of the Corporation Tax Act 2009, which is in tab 3 of the authorities bundle, page 10.
And the main purpose of that is to deal with the separate point that this is expenditure incurred very often before you actually begin trading, in which case.
Right.
So otherwise, again, you wouldn't get a deduction because it's not in the course of the trade that you incur the expenditure.
Absolutely right, my lord. And the section permits then the deduction of pre-trading expenses, where they're incurred.
And this would work out better for you, wouldn't it? Because you wouldn't have a writing down allowance. You put it all down from the start.
Well, it depends on how it's accounted for, because it may be amortised, and I'm afraid I don't have the answer to that off the top of my head. So I'm not sure I can say whether it is better.
It would be amortised because for accounting purposes it was treated as capital.
I think it would be capitalised, yes.
Yes.
But I'm making submissions without instructions on that point. So I can't say whether it's better or worse. It is an alternative position in terms of the tax code. So Section 61 enables the deduction of pre-trading expenses. There is a timing limitation. So the expenses have to have been incurred within 7 years before the commencement of the trade. So there's that qualification and limitation. There is also a restriction in terms of whether the profits would be allowed had they been incurred when the company was trading, which is what brings in various other qualifications, including the restriction on the deduction of capital expenditure in Section 53, which is on page 9. HMRC had also argued that the amounts in question were not incurred wholly and exclusively for the purposes of the trade, so that required a consideration of Section 54, but that was ultimately not pursued. So we're left only with the restriction of Section 53. So the position is that the expenditure can qualify as deductible under Section 61 to the extent that it was incurred within 7 years before the respective trades were commenced. And that's a question of fact. And to the extent that they did not amount to capital expenditure. If I can then turn to the authorities on the revenue capital divide. They've recently been reviewed by the Supreme Court in the Centrica case, which is in the Authorities Bundle Volume 2, tab 29. Page 595 in the Authorities Bundle. And the case was concerned with the deductibility of professional fees paid by Centrica to third-party professional service providers in connection with the disposal of certain subsidiary companies. HMRC denied the deductions on the grounds that they were not expenses of management of Centrica's investment business, and also on the grounds that the expenses were of a capital nature. By the time the case got to the Supreme Court, it was settled that the expenses were those of managing an investment business, but there remained a dispute as to whether they were capital in nature. And Centrica's appeal to the Supreme Court was on 2 grounds. The first was that the test for identifying whether investment management expenses were of a capital nature was different from the test that applied to trading companies under Section 53. And the second ground was that even if the tests were the same, the expenses were of a revenue nature. And as regards the first point, the Supreme Court held that the approach to adopt was the one that applied under Section 53, which then brings in the established case law about the distinction between revenue and capital. So that meant that the court had to review authorities in that area, and consideration of that point begins at paragraph 62 in the judgment of Lady Simler. This is at page 614. So Lady Simler notes that the cases make clear that there's no single test or criterion that will be decisive.
And it does make the important point, which used to be disputed surprisingly often, as to whether it's a question of fact or law.
Yes.
And it is now, well, Beecham and Woolworths is the key case. I mean, it makes it absolutely clear it's a question of law. So it's a binary answer. Either it's one or the other. It has to be capital or income. It can't be both.
That's right.
And it can't be left in some kind of grey zone where it's just a kind of Edwards and Bairstow type question.
Yes, and sometimes, as is recognised by Lady Simler, it can be difficult to put it one side of the line or the other.
Absolutely.
In fact, quite often it can be. But the body of case law is useful in providing illustrations of the approach adopted in particular sets of circumstances and the kind of indicia or factors regarded as relevant in those circumstances. There are also certain principles that have been derived from the cases, albeit recognising that they were decided in relation to widely different businesses and circumstances. As Lord Wilberforce explained in Strick, the principles to be derived from the cases are useful provided it is recognised that they cannot automatically be applied to a case involving a different business and different circumstances. Then there is a reference in 65 to the dicta of Viscount Cave in Atherton, where an expenditure is made not only once and for all, but with a view to bringing into existence an asset or an advantage for the enduring benefit of a trade. I think there is very good reason, in the absence of special circumstances leading to an opposite conclusion, for treating such expenditure as properly attributable not to revenue, but to capital. And then there's a reference to the speech of Lord Wilberforce in Strick. What's the nature of the payment, and for what was the payment made? These, together with the third question, namely how that for which the payment was made was to be used, were stated by Justice Dixon in his classic judgment in Sun Newspapers Limited and Federal Commissioners of Taxation. There are, he said, three matters to be considered: the character of the advantage sought, and in this its lasting qualities may play a part, the manner in which it's to be used, relied upon or enjoyed, and in this, and under the former head, recurrence may play its part, and C, the means adopted to obtain it, that is, by providing a periodical reward or outlay to cover its use or enjoyment for periods commensurate with the payment, or by making a final provisional payment so as to secure future use or enjoyment. I may add to this another statement by the same learned judge in the later case of Holstrom's: what is an outgoing of capital and what is an outgoing on account of revenue depends on what the expenditure is calculated to effect from a practical and business point of view, rather than upon the juristic classification of the legal rights, if any, secured, employed, or exhausted in the process. In other words, what matters is the true nature of the payment, what it's made, and the object or effect of the expenditure, together with the factors set out by Justice Dixon in the quotation from Sun Newspapers that might be relevant on the particular facts of the case. These are all questions of objective analysis, not to be determined according to the subjective motive or purpose of the taxpayer, as was made clear by the House of Lords in Lawson and Johnson Matthey. And the taxpayer in Centrica placed considerable reliance on Johnson Matthey, and Lady Simler explains why the case is distinguishable. And then at 70, page 616, the learned judge goes on to say, there are many cases, particularly those involving trading companies, where difficulties can arise in determining which side of the revenue capital line the expenditure in question falls. In these cases, a helpful starting point is to identify whether some form of asset has been obtained. See Tucker and Granada Motorway Services, where Lord Wilberforce recognised that this approach can produce arbitrary results, but concluded that it provides a basis for distinguishing between capital and revenue expenditure and should be maintained. And then at the start of para 72, there's a reference to Mr. Hewitt's reliance, Mr. Hewitt for the Council for the Revenue, on several cases to illustrate the proposition that money expended to achieve the disposal of an asset, tangible or intangible, is generally treated as capital in nature. One of those cases was ECC Quarries and Watkis, which is referred to at paragraph 73. It was referred to by Mr. Hewitt as closely analogous with the present appeal. The case concerned legal and professional charges incurred on preparing and presenting applications for planning permission to enable the taxpayer company to exploit sand and gravel pits on land it acquired. As a matter of commercial accounting, this expenditure was properly treated as being chargeable against revenue, but the question was whether, as a matter of law, the expenditure was capital. The expenditure was incurred in connection with the making of planning applications themselves, as opposed to an earlier advice stage, and subsequently to persuade the local authority and the minister to grant the permission sought. Applying the identifiable asset test, Mr. Justice Brightman held that the expenditure was capital expenditure. And then, just looking in the quoted part there from the decision, halfway through the first paragraph, it was a lump sum for an enduring advantage, static in nature, in the sense that it was not the planning permission which would produce the profit, but the subsequent operations of working and winning the minerals. On common sense principles and with the benefit of judicial guidance in the reported authorities, it seems to me that the expenditure was of capital and not an income nature. To use the words of Lord Wilberforce in IRC and Caron, the planning permission, if obtained, would in some sense have been an intangible asset of a capital nature. If that's right, money expended in seeking to acquire such an asset must equally be expenditure of a capital nature. And then drawing the threads together, although there's no single test to be applied in all the circumstances, in most cases, the objective purpose for which the payment is made is likely to be an important indicator. Where a capital asset, whether tangible or intangible, is obtained or can be identified, the starting point is to assume that money spent on the acquisition or disposal of the asset should be regarded as capital expenditure. And then Lady Simler notes that there may be particular features of payment or circumstances which displace that assumption. It may be helpful to consider the nature of what was obtained, the advantage by the expenditure, including whether it is lasting or not, how it's used or viewed in the business, and how the advantage was paid for. Where money spent on improving an asset or making it more advantageous, the payment is recurring, may indicate that it's expenditure on maintenance or upkeep and therefore of a revenue nature, whereas a lump sum payment may indicate the opposite. And then Lady Simler applied those principles and concluded that Centrica's expenditure was incurred with the object of ridding itself of an onerous capital asset, and therefore it qualified as capital expenditure. And there was just one more authority that I did want to take the court to, if I may. I'm conscious of the time. And it is Granada and Tucker, which is referred to in the set of cases referred to by Lady Simler. It's in the authorities bundle at tab 17. So volume 1, it's page 186. Was concerned with the classification of a payment that was made by Granada Motorway Services, effectively to rid itself of an onerous provision in a lease that it had in relation to motorway service stations. So they negotiated a change in the term of the lease with the Minister of Transport in return for a lump sum payment, and the question then arose as to whether it was deductible as revenue against the taxpayer's profit. The majority of the House of Lords concluded that the expenditure was capital. Lord Salmon dissented. The speeches of the majority, and in particular the speech of Lord Wilberforce, contains a helpful summary of the principles. If your lordships would turn within the report to page 189 of the authorities bundle. And many of the principles have been extracted by the Supreme Court in Centrica. There's just a couple of specific points that I'd refer to for this. So, just below letter C on page 189, Lord Wilberforce makes the point that the key to the present case is to be found in those cases which have sought to identify an asset. In them, it seems reasonably logical to start with the assumption that money spent on the acquisition of the asset should be regarded as capital expenditure. Extensions from this are first, to regard money spent on getting rid of a disadvantageous asset as capital, and secondly, to regard money spent on the improving of the asset or making it more advantageous as capital expenditure. In the latter type of case, it will have to be considered whether the expenditure has the result stated, or whether it should be regarded as expenditure on maintenance or upkeep, which would be revenue, and some cases may pose difficult problems. And then over the page, there's a reference to Strick, which is referred to in Centrica. And then I just wanted to draw your Lordship's attention to this. I pass to the other side of the narrow dividing line. It's between letters C and D. Nearest to this line is the case in this house of IRC and Caron, which is referred to in some of the extracts in Centrica, but is not specifically referred to. There, the expenditure was incurred in order to procure a modification of the company's charter in such a way as to enable it to trade more properly and to facilitate day-to-day operations. This house held that the payment had a revenue character. Unless indeed it could be said that the charter was a capital asset, it is difficult to see what other decision could have been given. In the course of my opinion, I use these words: the disposition of a source of liability may be equivalent to the acquisition of a source of profit, an extension perhaps, but not an exception, to the principle that in some sense or other, an asset of a capital nature, tangible or intangible, positive or negative, must be shown to be acquired. If this is correct, and until a case arises which constitutes a true exception, I shall continue to think that it is, the present expenditure cannot be brought within the capital class. And then you have to pay attention to the following words. With due caution against using these words as if they were statutory, I adhere to them. They were, of course, directed to excluding cases where no capital asset could be seen or identified, which was that case. I had not intended to narrow the conception of capital payments to the case of acquisition of an asset. Clearly, expenditure on a capital asset may fall within the principle. So, one has a statement of the working assumption that acquisition of an asset would tend to suggest capital expenditure. Also, the point in Karen that if one can't identify within that category of case a capital asset, then one would tend to the conclusion that the expenditure was revenue in nature. That
is a convenient moment.
Is all I want to say about the case law, and indeed is a convenient moment.
In which case, we'll start again at 10:30 in the morning.
What rights